Hello everyone. In this video, we are going to understand about one of the questions that were asked in this exam. That is question number 31 in the set A of the prelims exam that was conducted. This question is about what exactly do we mean by due process of law? Fine. Now this question seems to be a very small one. It seems to be a very simple one, but the explanation would require us to understand some nuances. What I'll try to do is to make you understand them in as brief manner as possible. Fine. So let's start with what exactly do we mean by due process of law. See, when we talk about the way in which democracy functions, there is this cardinal principle of separation of power that was given by Montesquieu, which essentially says that for state to function, there are three basic organs. One is legislature, second is executive, and third is judiciary. We know for a fact that legislature has been given the power to legislate. It makes laws. You have executive, which essentially includes the government, political executive, council of ministers. You also have permanent executive. It essentially would mean what? That is people who are going to implement laws. And third is judiciary, which performs two functions. The first function, as we know, is judicial administration, justice administration. But one another function that judiciary is essentially performing is called as judicial review. Now, the question is, what exactly do we mean by judicial review? Look, indeed, what we have done is to create a legislature which is going to legislate laws. But the question is, just because they have been given the authority to legislate laws, because in democracy we have given our vote and then there's someone who essentially has been made as a representative, now they have the capacity to make laws, does it mean they can create any law that they want? Certainly not. It should be that we need to keep some limits on the power of the legislatures to legislate laws. For example, let's say today if the government wants to, or other legislature, Lok Sabha, Parliament would want to pass a law where it would want to say the fact that there is not going to be any election for next 200 years. One would argue, what is this? If at all they want to create a law by which they say the fact that we can kill anyone, any citizen, there cannot be any action that can be taken against the government, there cannot be any action that can be taken against the political executive for the reason we have the power to make laws. Certainly not. That means there should be ways in which we are able to impose limitation on legislature. That limitation is being imposed by application of constitution. In Indian context, we know there is something called as Constitution of India, and we know by definition legislature, while can legislate any law, what they cannot do is to make a law which goes against any of the provisions of the constitution. But the question is, who exactly is checking whenever legislature do end up creating a law which is against the constitution? In this respect, what we have done, judiciary, under judicial review, you should be keeping an eye on legislature. You should be looking into all the laws that has been enacted by legislature, and you need to ensure all these laws are within the limits of the constitution. This is how we essentially are performing judicial review. Judiciary is performing judicial review over legislature. Under judicial review, what legislature, that is your judiciary, is also doing? It is performing judicial review over executive. What exactly is the idea of performing judicial review over executive? Well, executive, any of your action cannot be against constitution. That is, it cannot be that in any of the actions that you're taking, in any of the actions of a police officer, IAS officer, any of the executive order passed by council of ministers, you cannot do anything which is against the constitution. Your executive action cannot go against right to equality, right to equal opportunity, etc., etc. And it should be within the limited restrictions given under the constitution. In this respect, this is how we are able to perform judicial review over the actions of executive. There is one more aspect to the way in which judiciary is keeping an eye on the functioning of executive. That is, for executive, while they can pass all sorts of executive orders, what they cannot do is to pass an executive order that goes against a law in place. For example, for the sake of example and hypothetical example, that let's say there is a law that has been created by the legislature that there will be a 500 rupee fine if at all you're not wearing a helmet. In this respect, now there is a law which has been created by legislature. What executive cannot do is to impose a law more than 500 rupees. Why? It would be to violate the law in place. That means when judiciary is performing judicial review over executive, Not just it is checking that executive is not acting in its action in any manner which goes against the constitution. It is also looking into what? That their actions are also not against any law in place, because that again is against the principle of democracy, against democracy. Now that we have understood it, let's come to the second part. The second part is, okay, now that we have understood the fact that there is something called as limitation of the constitution on the way in which legislature is supposed to legislate, executive is supposed to implement laws. What if legislature essentially is creating a law while it may not be contravening, it may not be in contradiction to the constitution, in substance, in its procedures, the law is arbitrary, the law is illogical, the law is as if they are not applying any logic, any form of justice, any form of fairness in that law. For example, for the sake of example, I'm saying, let's say today legislature creates a law by which it says that drinking Coca-Cola between the time 12 noon to 2 p.m. is a crime. And this punishment essentially involves that you will be put in jail for 2 years. In this aspect, what exactly, let's say the rationale given by the government says the fact that, well, we do not want people to consume so much of aerated drinks, and that is why we essentially are putting this that is restriction that it is illegal for you to consume any aerated drinks between this time to 12 p.m. to 2 p.m. In this aspect, what is the idea? Certainly this law is illogical for the very simple reason, how exactly are you controlling consumption just by making a law which prohibits consumption of this between this time, that is in these 2 hours. The other part of it is what? The other part is that fine that you have created this law, but are there different and better ways by which you can achieve it? For example, let's say you would want to impose sin tax on sale of Coca-Cola, sale of all aerated drinks. In this aspect, what exactly is the issue that we are having? We certainly have a law which by and large is not contravening any constitutional norm, any constitutional provision, but certainly to a layman it is coming across as something which is arbitrary, which does not have any logic. The question here is, can it be that under judicial review, judiciary can do something about it? And this is where comes the doctrines of judicial review. In this aspect, there are 2 main perspectives. The first perspective is that, well, the whole idea of democracy works that people, society essentially elect their representatives and they decide what is right and what is wrong for the people. It is not the job of judiciary to interfere. Fine, you can look into those aspects which essentially deals with constitutional limitations, but certainly it cannot be that you want to look into a law from standpoint of what you think to be right or wrong, what you think to be arbitrary or not arbitrary. If the society believes the fact that something is illegal and such a law should exist, the best way in which it can be reflected is by a legislature, and judiciary should not have any role to play in it. Fine. What is the second part? The second part is the whole idea of judicial review. The whole idea of responsibility of judicial review and judiciary entails that judiciary should be checking that the power to make laws are not being exercised in an arbitrary, unfair, unjust manner. In this respect, what is the idea? Certainly, if at all a law is being created in a manner in which what is happening, you essentially see a lot of arbitrariness, a lot of randomness in the way in which the law has been created, the law in which the law is getting applied. There should be something that judiciary should be able to do. So these are the 2 perspectives that we are able to see. One essentially says that judiciary, you should be looking only to the constitutional limitations, and you should not be looking into the spirit of the law, the logic of the law. The other perspective entails what? That you should be looking not just on the idea of that every constitutional procedure has been followed, but also you should be looking into whether the law is arbitrary or not. Right? In this aspect, what we are trying to say, what we are trying to understand is what exactly is the way in which judicial review should happen by which due process of law is achieved. In this regard, the question is, what do we mean by due process? Under due process, essentially there are 3 forms, right? In due process, there are 3 forms. The first is what we call as pure procedural due process. Second is procedural due process. And third is substantive due process. Right? Let's try to understand each of them in a very brief manner. Pure procedural due process essentially says that, well, judiciary, you have been given the role of ensuring things are happening as per the constitution. In this respect, if a law has been made, all you need to do, whether simple majority was achieved in Lok Sabha, whether simple majority was achieved in Rajya Sabha, has it been assented by the president? And if that is the case, it is not your business to intervene into what exactly people believe, legislature believes to be a good or bad law, right? This is what we call as pure procedural due process. That is, we are just taking to the constitutional procedural limitations. We are not getting into what? We are not getting into the way in which the spirit of what you want to achieve with that law is getting achieved or not. The purpose is getting achieved or not. Make sense? Then what we have is procedural due process. What is procedural due process? See, the idea is that it is fine that you can create a law. The substance of it says something like this, that is, you want to create a law by which you want to control consumption of aerated drinks by saying the fact that for these 2 hours no one can consume it. If at all they want to consume it, it is a punishable offense. Fine, this is something that we call a substance of the law. But what if you are also adding to it and suggesting what? You're adding to it and you're suggesting that, well, all the people who are getting convicted under this, that is, let's say there is Mr. X. Mr. X was found to be drinking an aerated drink in this period. In this respect, what is the idea? The whole idea is the fact that Mr. X will need to be arrested. But in the law, what you have included, Mr. X, you will not be given a right to attorney. That is, you cannot consult a lawyer who's going to defend you. That means as far as the substance of the law is concerned, that is one thing. What we are talking about is how exactly it will be implemented. I hope you're able to understand what I'm trying to say. That what we are talking about is the procedural part of the way in which the law will need to be implemented. And certainly in any democracy, you would not want people to not have a right to consult their attorney. For the very simple reason, you would think the fact that how exactly expect a layman to understand all nuances of laws, all fundamental rights, how exactly the legal protection works. In this respect, what exactly is the idea? Substance of the law is problematic, but the procedure of the law, the way in which it should be implemented, is also problematic. In this respect, when you talk about procedural due process, you will not look into the substance of the law, pretty much the way in which pure due process work. But in procedural due process, what exactly you look into? The procedural aspect of it. That is, it is unfair to Mr. X that he is not being provided a lawyer. It is unfair to Mr. X that he is not being given a proper legal defense so that he is able to defend himself. Judiciary under judicial review will say that we have nothing to do with substance. We essentially will need to do what? We need to ensure that justice prevail in the way in which the law is getting applied, because that is the domain of judicial administration. Fine. Then what you have is a system called substantive due process, which is getting followed in USA. In USA, they have a very strong judiciary, and the reason is not just judiciary can look into the procedural correctness, it can also look into what? It can also look into the substance of the law, the substantial correctness of the law. That is, judiciary can say that why exactly you want to create a law. I'm right now talking about US judiciary. Their Supreme Court say that why exactly are you creating a law by which you want to ban consumption of aerated drinks only for these 2 hours? It seems illogical. Not just we are saying the fact that not giving a lawyer to this person is problematic, that is the procedure is wrong. But what we are also saying is the substance of the law is absolutely wrong. In this regard, what exactly judiciary has done? Judiciary essentially has established that we possess the power not just to look into procedural correctness, but also to look into substantive correctness of the law. That is, an arbitrary law cannot be accepted. This is absolutely wrong. Make sense? Now that we have understood procedural due process, substantive due process, the next question that we are having is, whenever we are increasing the scope of due process, what exactly are we trying to achieve? That is, we are increasing the scope of due process in a way in which we would want to ensure proper application of justice to happen. The moral value of justice should prevail in the way in which the law is happening. In procedural due process, we are focused mainly on the justice with respect to the application of procedure. In substantive due process, we are concerned about not just the justice with respect to procedure, but justice also with respect to the substance of the law. I hope you are able to understand what I am trying to say. And in this regard, when you say the word justice, the whole idea is that you would need to understand that this justice is nothing but principle of natural justice. As I had said at the beginning of this lecture, that Natural justice is something, and due process again is something that requires a lot of time to understand in detail. But in brief, when we talk about natural justice, what we're trying to achieve is it's not just the letter of the law, it is also the spirit of the law that needs to be protected. Different societies, different countries, and constitutions have different interpretations of natural justice, but three principles generally are core to understanding natural justice, principle of natural justice. The first is whenever two parties are fighting, none of those parties can actually be a judge in that case. Let's say A and B are having a dispute, and A who wants to take the matter to the court, there will be a judge who will decide who's right, A is right or B is right. But it cannot be this judge is either A or B. That means it cannot be the parties who are conflicting. One of those parties is a judge in that case. That goes against the principle of natural justice. To it, the second part is whenever there is a case that is happening between A and B, not just the fact that judge cannot be A and B, but whosoever is accused should be given an opportunity to be heard. That means just because A says that B has done something wrong does not mean that B is guilty. B should be allowed to come and give his defense. In order to give his defense, B would require some sort of notice. That is, we are giving you a notice of 1 month. These are the charges against you, and we would want you to come out with a defense after 30 days and defend yourself in a jury, that is, before a jury, before a judge. In this respect, again, what is the idea? The idea is that if you want natural justice to prevail, first principle, it cannot be that judge is anyone between A and B. The second is that when you want natural justice, the person who is being accused, who is being charged with an offense, should be given opportunity to come and explain himself, right? Then there is third principle, which is getting followed in different ways across the countries, different countries, but in USA, it is considered to be at the core of natural justice. That is, that the authority should be exercised in a bona fide manner. Now, what is authority, what is bona fide will take some time for us to understand, but put it very simply, while the law might be same, the application of law should happen in a way in which it is being fair to everyone. It is not being done in a discriminatory manner. It is not being done with a specific targeting. It is not having any preferential treatment. Let me give you a simple example, which is generally at the crux of many of the cases which are getting struck down by court whenever principle of natural justice is raised. That is, a lot of time, police in USA have been found to be arresting people from African American descent with respect to, that is, possession of that is contrabands, that is things that are not allowed, things that are illegal for you to possess, let's say drugs, fine. In this regard, what we have, let's say there's a person called Mr. Y, and this Mr. Y is a person from African American community. This person was arrested by a police officer because this police officer, while searching Mr. Y, found, let's say, some drugs in possession of Mr. Y. What exactly will be the question that will be asked by judge? Judge will say, what made you believe, Mr. Officer, to go and search Mr. Y? If at all the reason why the officer decided to go and search Mr. Y was because Mr. Y is of African American descent, then one would say the authority to search was not exercised in a bona fide manner. In other words, what exactly are we trying to say? That natural justice was not practiced. You essentially are targeting this person, and even though we have found something which is illegal in the possession of Mr. Y, it will still not be, that is, Mr. Y cannot be charged guilty of it for the reason that his rights were not protected. That is, authority was exercised against him in a manner which cannot be called as bona fide. That is the third principle. That is, exercise of authority should not happen in a manner in which one can argue it is arbitrary. Make sense? Chalo. Now let's look at the options that we have with respect to due process of law. What exactly at the essence means due process of law? Of course, the answer will be principle of natural justice that I have explained. Now, I can understand that many of you may not be knowing the theoretical underpinnings of this question which I have just explained, but then there can be another ways in which you can actually solve this question. For example, one can certainly say equality before law cannot be the right option for the reason what we know is that equality before law is coming under Article 14. It is linked to rule of law. It is also linked to equal protection of law, which is another facet of Article 14. But when we talk about due process of law, it is connected to Article 21. that is procedure established by law. So certainly, based on common sense, by simple reading of polity, one can argue this cannot be the right option. Then what we know is the fact that what we are using is the expression procedure established by law. If this is the expression that we are using under that is under Article 21, certainly both cannot be the same thing. Otherwise, we would have used due process of law. Again, this cannot be the right option for the very simple reason procedure established by law is indeed different from due process, is why we decided to keep it under Article 21 of Indian Constitution and not use the term due process of law. Then we are left with two options. One is natural justice and second is fair application of law. What is fair application of law? Fair application of law, if you think about it, is actually capturing only one aspect, and that is authority should be exercised in a bona fide manner. That is the extent to which the meaning of the statement is. Certainly, it is one of the subset of natural justice, but due process is not about fair application of law. It is about natural justice, principle of natural justice in its holistic sense. That means the most appropriate answer indeed would be natural justice. I hope you are able to understand how exactly we could have gone about attempting this question. And even though we may not be having complete knowledge, it certainly would have been that we can still make some elimination and get to the right option.